avoiding probate without trusts, taxes, lawyers in some cases, um, and even a will. I'm Jason Taken, owner of Taken Law, and I shot a quick video on this earlier over on some other platforms, but I wanted to go into a little more detail about how to keep real estate out of probate without needing a trust and without imposing any additional tax liability. In Illinois, there are a couple different mechanisms, and some of these mechanisms apply in other states, but they're called different things. And I'm not an attorney outside of Illinois, so I'm not going to speak on those. But in Illinois specifically, one of the statutory schemes or something that was statutorily created is called the transfer on death deed. A transfer on death deed basically turns your real estate, or it adds, I should say it like this, it adds beneficiary designations to your real estate. So much like your Roth or your 401k or really any other beneficiary designation vehicle that you might have, it takes your real estate and adds that functionality to it so that if you were to pass away with the title to your home in your name, once those death certificates are obtained, you could basically transfer that title without any additional work. There's some paperwork, but in terms of probate trust, things like that, that's what I mean. So transfer on death deed, there's a statutory related scheme, and there are templates out there. Really, you should just call an attorney. Some attorneys don't like them. There's a lot of back and forth in the attorney community about these deeds because there are exceptions in the statute that make them different from warranty deeds and things of that nature. So make sure you do it right. Make sure you get a qualified attorney to help you with that, and it gets recorded. One of the big things is that transfer on death deed has to get recorded before the person passes away, or else it's not effective. So be mindful of that. Another way to keep real estate out of probate without a trust or tax is to hold title in one of two ways: joint tenancy with the right of survivorship, or tenancy by the entireties. Tenancy by the entireties is reserved for married couples, and the difference between that and joint tenancy really is that when the decedent passes away and the surviving spouse still remains, it protects the home from the decedent's creditors. So that's one of the benefits of having that, and it's reserved for married couples. Another type of title ownership is joint tenancy with the right of survivorship. What that does is 2 people own a home, 3 people own a home, whatever. 2 people own a home. When one person dies, the remaining person gets full ownership of the house. If they weren't joint tenants and they were tenants in common, what would happen is if there were 2 people, A and B, and A passed away, A's heirs at law would get A's portion versus it transferring to B. So that's a difference. And then you would obviously have to go through probate and all that stuff with A's share. So joint tenancy is very helpful because it keeps the home out of probate, and you don't even need a trust. Now, should you have a trust? Should you have a will? That's your personal decision. If you want to learn more about those things, you can give us a call. My number should be around this video somewhere, or just go to the website. That's all I want to talk about today. Look forward to talking to you. Bye.